So delighted to be able to present to you today. And what I have in mind is to start by giving you a brief profile of my career, and then followed by telling you something about Ellinson Legal, its services, approach, and its qualities, and then to share a brief introduction about the process for the legal process when it comes to division of assets and liabilities in the context of divorce and separation. I had intended to do a case study, but this morning I realized I didn't have time, so perhaps next time I'll focus more on a case study. And then I'll conclude with some referral requests. Okay, so in terms of my career history, well, I'm now founder and principal of Ellinson Legal, have been for several years. Prior, these were my positions. I was Chief Legal Counsel with Monash Commercial, which was intellectual property commercialisation arm of Monash University. I was Special Counsel and Consultant in two of Australia's largest national law firms, Blake Dawson, now known as Ashurst, and Clayton Utz. I was Chief Legal Counsel at GE Capital IT Solutions. I represented Victorian in-house corporate lawyers on the Council of Law Institute of Victoria. I chaired the Law Institute of Victoria's Intellectual Property Committee. I was partner of Dunhill Madden Butler, which is a major national law firm. And I've had articles published in leading law journals, including one of the articles was referred to in the judgments in two federal court cases. So, to Ellinson Legal and our services, we assist clients who are going through divorces and de facto separations. We also advise clients who are preparing before the decision to separate. And we prepare agreements for clients who are commencing or continuing marriages or de facto relationships. We guide clients from concern to calm and fair outcomes, compassionate and wise family law support. Our approach is holistic, practical, and strategic. Court action is a last resort, but sometimes necessary. And we work with leading barristers, including regarding second opinions and court advocacy. Integrity is a hallmark of Ellinson Legal. We have emotional intelligence and listening skills. We excel in legal advice, negotiation, and preparation of documents. We have expertise in de-escalating, managing, and resolving conflict. And we know the importance of and practice clear communication. Today, I'd like to focus on the process, the legal process, when it comes to division of assets and liabilities. Information gathering is, of course, very much a critical part of that. Starts with basic information, length of the relationship, are there children, ages of the children, and it just builds from there. But the core of it all is to identify the assets and liabilities of the relationship, whether the assets and liabilities are in the name of the one partner, one spouse, or the other spouse, or the other partner, or in both names, doesn't matter. Just what are the assets, what are the liabilities, and list them. And of course, as you can see next to the dot point information gathering, we seek from the client the financial documents which evidence that. So, the bank statements, superannuation statements, mortgage statements, records of share portfolios. If there are trusts, then trust documentation. If they're businesses, then business financial statements. And of course, evidence of income, earning capacity, tax returns, pay slips, and the like. In terms of what are the facts, so once you've identified all, you've got the information and of the assets and liabilities, what are the factors relevant to the appropriate division? Well, in very broad terms, the first factor the law looks at is what were the contributions of the parties? And that's financial contributions, but also non-financial contributions and contributions as homemaker or parent. Family violence considerations are also taken into account in that factor. Then the law looks at what are the future needs of the parties. Who is having primary care of the children? What are the income earning disparities between the two? What's the health situation between the two? Are there any health or special needs of the children with whom one of them has primary care? So these are all factors which are looked at. One, contributions, financial and non-financial. Two, non-financial contributions. Two, future needs. And third, a general category which is called just and equitable. What is overall fair? And there are a variety of factors which are looked at there. You may have heard of something called spouse-partner maintenance. Well, that's separate to division of assets and liabilities. Spouse-partner maintenance and it's separate to child support as well. Spouse-partner maintenance is if one of the parties really can't adequately support themselves coming out of a separation and the other partner can. and has the capacity to give that support. It tends to be for a limited period, often during the period of the working out of the appropriate property settlement. But for those who are in particular need coming out of a relationship, especially, for example, if it's a family violence situation and there hasn't been access to funds and the person has no money to access, then it certainly becomes relevant. And then, of course, throughout the process, we're looking at issues of concern, including urgent issues. Access to funds by the client is one, but are there urgent issues concerned with, for example, the other party might dissipate the assets, try and dispose of an asset, try and hide the asset. So these are all things to just bear in mind. But having done all that, we then come to give some preliminary advice as to a reasonable range of settlement and also advice regarding issues of concern. And then we're then write to the other partner or spouse, or if legally represented, their lawyer, and including in that letter, we seek financial documents, we exchange financial documents, and negotiations can then occur between lawyers, obviously in close consultation with clients. If there's a dispute on what the value of a particular asset is, then one can always access an independent expert, and that usually solves that issue, or should. And if the thing still needs to help in resolving, then we can always access a mediation with an independent mediator, and tend to get barristers involved, or generally barristers get involved in representing in mediations. And then once the agreement is reached in principle, the next step is to document it. And you may have heard of binding financial agreement or consent orders. They're the two documentary steps to document an agreement. And if an agreement can't be reached, then court action. But with court action, it's not like we're going straight to final trial. Court action gets managed very closely by the court. There are procedural hearings, and there's plenty of time to negotiate. And indeed, there's also a mediation facility within that process. Okay, now we also, to help clients who don't have funds to pay legal costs during this process, we collaborate with Just Fund. And Just Fund is Australia's only dedicated funder of legal costs incurred in obtaining a divorce or de facto financial property settlement. They don't require any payment until settlement is reached. And in conclusion, referral sought. Anyone who is considering separation or going through separation, whether they're in agreement with their ex-partner or spouse, or whether there's required negotiation, or indeed if they're in high conflict. And further, referrals would be very much sought from professionals or businesses who service people who may be considering or going through separation. Thank you very much.